So there's no formal introduction, so I'm just going to introduce myself. My name's Paul Rushkin, head of Business and Finance Department over at Rosenn, Jenkins and Greenwald. We're a full-service law firm from Wilkes-Barre, Pennsylvania. We're literally just a few blocks over. It's really our pleasure to come over and talk to you folks today. There's some new things going on in the down in Harrisburg. They've created some exemption for you all as veterans or reservists to be able to form entities without paying a business fee. So what we wanted to do was, and we'll sort of issues we're going to cover in this is, we're going to let you know available forms of entity in Pennsylvania in case you all want to form a business for the purpose of your veteran or reservist-owned business. Let you know about some choice of entity considerations that you all might want to think about in selecting which entity. Let you know about the things that are being afforded to you under these new laws that have come into effect to allow you to avoid these business fees. And then finally, we want to let you know our firm is offering some pro bono services to veterans or reservists to aid them in forming an entity, just our way of giving back. So we're going to go through it. If anybody has any questions along the way, feel free. I'll leave time at the end for questions, but if you want to interrupt, I don't mind at all. Okay?
I'm interested in LLC.
What's that?
LLC, I want to know what that means.
So it's a limited liability company. That's one of the ones we're going to go through. It's actually become, in a lot of respects, the most popular one for a lot of different reasons, but we'll go through the whole thing. One thing I want to mention to you is the presentation after mine is also going to be about choice of entity, but on slightly different topics, not unlike a lot of other things. There's a bunch of different avenues you can talk about around this. Mine's really going to be just focusing on some choice of entity considerations that should be made. We'll introduce all the different types of entities to your point, and we'll let you know about this exemption. We'll let you know about these other options. I looked at the next presentation. That's also going to have some great information that deals with other aspects of it, so you won't be too bored with two presentations on it back to back. So first things first, let's talk about the types of entities. LLC, or limited liability company, is one that's become very popular. That's why it's on the top of the list. There's also there's an S corporation and a C corporation. We'll talk about the differences between those. There's a limited partnership. There's also a general partnership. There's also a limited liability partnership. We'll explain what all those are. And then there's something called a sole proprietorship, and we'll get into what that means as well. So all of these different entities are governed by different statutes. And I just sometimes think it's helpful if you can sort of see where they are if you ever want to look and read about more about them. With the exception of the business corporation law, which was first adopted in 1988 and has had a series of amendments, all of the new laws, all of the other entities are governed by laws which were all redone in 2016. They've all been redone to make the statutes that govern them very similar, and it's become a much more streamlined statute from that perspective. So the LLC is governed by something called the Pennsylvania Uniform Limited Liability Company Act of 2016. The LP is governed by the Pennsylvania Uniform Limited Liability Partnership Act of 2016. The general partnership is governed by the Pennsylvania Uniform Partnership Act of 2016. And again, the C-Corps and S-Corps are by the Business Corporation Law, or the BCL, which is from 1988. There's also an LLP. There's a specific section of the code that deals with when you make a registration to cause a GP or an LP to be registered as an LLP, and we'll talk about that as well. Okay, so for each of these entities, what we wanted to do was just give you a basic overview on sort of how they're structured. So an LLC is formed by filing what's called a certificate of organization with the Pennsylvania Department of State. We're going to explain later how you can do that free of charge, but that's the form that needs to be filed for that purpose. It's owned by members, so as we go through this, the owners of these different entities are called different names, and the managers of these different entities are called different names, but it's all the same. For each entity, there's the people who own it, and then there's the people who manage it. Sometimes those are the same people, and sometimes they're different, but as we're going through this, I want to make sure you just see the terminology that's used with each of the different entities. So for LLCs, the owners are called members. And then the managers are either the members themselves or different people or entities that are called managers, okay? And then each of these entities are governed by different documents. So you'll see in each of them the sort of the rules of the game, the rules that are going to relate to the operation and management of the entity. For a LLC, it's called an operating agreement, and that's what will include all the rules for how the thing's going to work. Okay. Next, there's a C Corp. For a C corporation, you file what's called Articles of Incorporation with the Pennsylvania Department of State. The owners in a C Corp are called shareholders. They own shares in the company. The day-to-day operations are managed by officers. The president, secretary, treasurer, those sort of names are what's used for the officers of the corporation. It's governed overall, though, by a board of directors. You probably hear it a lot of times in different shows or whatever. The board of directors is going to take this action. That's only in connection with the corporation. Bylaws are put in place to set forth the rules about basically when you're going to meet as shareholders, when you're going to meet as officers, when the board meets, all that sort of thing. And then sometimes they put in place something called a shareholders agreement. So a shareholders agreement sets forth the rules amongst the shareholders as they agree upon. Sometimes it's buy-sell restrictions. So if you two both own a company together, you're the two shareholders, you might say, listen, I'm happy to be in business with you, but I don't want you to sell your stock to somebody else that I don't know. So if you ever want to sell it to somebody else, you'll offer me the first right to buy that, and you set forth the terms upon which you're willing to do it. Similarly, if you were to die, and let's say you don't want to be in business with his wife no matter what, or his children because you just don't think they know the business like you all do, you'd have the right to buy it out in that instance. So you set forth all the rules upon how that would be done, what the pricing is going to be or how you'll determine the price, how long it will be payable over, when you'll close, all that sort of stuff. And the reason they have these agreements is twofold. Number one is, rather than arguing about it or being in business with somebody you don't want to be, all the rules are set forth. And then number two is to keep it what's called closely held. Closely held means owned by you or whomever you wanted to be in business with, subject to you being able to buy people out in those instances. Okay, does that all make sense? And for an LLC, those same buy-sell restrictions are then in the operating agreement. Same sort of things we talked about with the corporation and the shareholders agreement, that's in your operating agreement, as well as the things that are normally in the bylaws. So in a corporation, it's really bylaws plus shareholders agreement includes all your rules. In an LLC, all of that's included in the operating agreement. SCorp is basically formed and governed the exact same way as a C Corp, with one exception. You file with the Internal Revenue Service something called an S-election. What the S-election provides for you is it says that corporation isn't going to be taxed like a C corporation, it's going to be taxed like an S corporation. And we'll talk about in a minute what that means. It's a preferable tax treatment for it, but it also comes along with some rules we'll talk about. So we'll talk about why you might want to do that. Same as with a C Corp, it's owned by shareholders, its day-to-day operations are done by officers, and from the standpoint of governance, it's the board of directors, same way as we talked about previously. They would have a shareholders agreement as well if they wanted to have a bylaws plus the shareholders agreement. With an LP, which as we said earlier is a limited partnership, that's formed by filing a certificate of limited partnership with the Department of State. It's owned by one or more general partners, and we'll talk about what that means later, and one or more limited partners. General partners are tasked with the management of the LP, and limited partners are basically silent partners. They have very little say in the management, but they're involved with they're involved with the ownership, and they get a share of the distributions for the company. But they don't really have any say in management except for a few limited issues. So if you want a limited partnership, it's going to be that, okay, some of the partners are going to govern this thing, and other ones are going to be silent partners. That's governed by a partnership agreement, which would include all the same things we talked about, like with the shareholders and with bylaws and shareholders agreement. All of that would be embedded in partnership agreement. There's slightly different rules, but the same concept. A general partnership is a little bit different. There's actually no document that you file with the state. So again, assuming you two are in business together, if you guys didn't form an entity, but by either an agreement you put in place or by your conduct, it was clear that you were conducting business together, then in that instance, you would be deemed to be a general partnership by operation of law. Like I said, there's no filing with the Department of State. The only thing you'd have to file is if the two of you wanted to conduct business under a fictitious name, like, something that, depending on your business, like Harry's Fire Services or something like that, that would be a fictitious name that you'd have to file with the state to register that name, but there's no actual filing to create the entity. Again, it's owned by at least two general partners. Under the law, you can't have a general partnership. To have a partnership, you have to have at least two people involved. Otherwise, you're a sole proprietorship. So it's owned by at least two general partners, and it can have a partnership agreement. An LLP, or a limited liability partnership, is either a general partnership or a limited partnership can become what's called a limited liability partnership by filing a registration for that purpose with the state. It's under Chapter 82 of the Pennsylvania Consolidated Statutes. And all it's for is basically to get the liability protection, which we'll talk about in a little bit, in a little more detail here, through that registration. Otherwise, it remains a general partnership or a limited partnership. It just happens to have this LLP designation for that purpose. Sole proprietor is, let's say you're in business by yourself and you haven't formed an entity, you're a sole proprietor. It's a default designation. It basically means someone who hasn't formed an entity who's conducting a business by themselves. There's no DOS filing, again, unless you wanted to have a fictitious name rather than your own name as the business. And it's owned and managed by that one person who's gone into business with themselves. There's generally no governance documents in place. When it's just you, you don't need to have an agreement with yourself about how you're going to do things, okay? So you heard about all the different choices of entity that are out there, all the different options. How do you pick one? And the way that you pick one is generally, for most small businesses, they're looking for two main features. The first feature is limited liability, which means that you're liable only to the extent of your investment in the entity. When you form an entity, you typically, in order to achieve the limited liability protection that we're talking about here, you've got to put some money into it. It's got to be capitalized. And so that, you've put money in, you're acting like a real entity, you've created a bank account, and you're entering into contracts in the name of that entity. That money that you put in is called, depending on the entity, generally a capital contribution. You've contributed capital to your entity. With a limited liability protection, the only thing that you are risking in the proposition, subject to you doing something negligently yourself, but as an owner, the only thing you're risking in the business is whatever you put in. So let's say you put in at the beginning $2,000, and over the course of time the business does well and you leave it in there. You end up having $10,000. Something goes wrong where you don't have insurance, where your insurance doesn't cover a problem that's come up. The only thing that's really subject to liability is that money that's in there, that $10,000 that's in there. Your personal assets are shielded from that liability. And so that's one of the principal reasons that people form these entities, and that's generally why a few of these forms of entities aren't preferable and generally aren't used unless people aren't cautious about it, okay? The next thing is what's called pass-through tax treatment. What pass-through tax treatment is when you form an entity, there's an entity on this level, and then there's owners on this level. So the entity is owned by, let's say, the two of you. Corporation, you form the two shareholders in it. There's a shareholder level, and then there's an entity level. With pass-through tax treatment, there's no income taxation of that top level. So there's no entity level tax. Everything passes through that top level, and it goes right down to the shareholders under individual returns. That's as compared to the double taxation which occurs with some of these entities, where in bigger companies, some of them are CCorps, like a Microsoft. You'll buy your Microsoft Word. When you send your money into Microsoft, it gets taxed on the corporate level. And then when it makes a dividend down to any of us who might own those shares of Microsoft through whatever, that's taxed again on the individual level. So you have a tax at the entity level and you get taxed again at the shareholder level. So what pass-through tax treatment does for you, especially with small businesses, it makes a lot of sense, is you never get taxed on that upper level. You might have taxes on an income tax perspective. You still have to pay sales tax, things like that, but not income tax. And that's on the state and federal level. You used to have to also file an S election on the state level, but that's gone away. It's just on the federal level. So what you look for, these are the two principal ones for a small business. So what you normally say, as you're trying to pick an entity, you say, okay, out of process of elimination, how am I going to get down to one selection? And what you normally say is, from a liability protection perspective, all of the entity forms provide the liability protection that we talk about. We call it a full liability shield. That means you're only liable to the extent of your investment. The only ones who don't provide that are a sole proprietorship. You have no liability protection if you're a sole proprietorship. A general partnership, unless it's done that LLP election that we talked about, that has no protection at all, no liability protection. And in a limited partnership, as we mentioned earlier, you have to have at least one general partner. And that general partner, the one that's tasked with the management under an LP, must have personal liability. So that general partner doesn't get the full liability shield that we're looking for. Now, the way you get around that is you either do an LLP, that LLP registration that we talked about, or you form another entity that serves as a general partner, and then whoever's going to manage it owns that entity. But the problem is, it's just too much administration. You have to form another entity, you've got to deal with it all the time. So for those reasons, the less than ideal liability protection mechanisms of the sole proprietorship, the general partnership, and the limited partnership, they're generally disfavored now. People don't use them as much. And they use instead either an LLC, a CCorp, an SCorp, or an LLP, because they're what we call full liability shield entities, okay? So now we're left with, you know you're not going to be a sole proprietor, you know you're not going to be a general partner, you know you're not going to be a limited partner. From there you say, okay, do I want to be a CCorp, do I want to be an SCorp, do I want to be an LLC, or do I want to be an LLP? The next one that sort of disqualifies one of these from it is you want pass-through tax treatment. And with pass-through tax treatment, there's no, remember we said no entity level tax. The CCorp doesn't have pass-through tax treatment. The only way a corporation can get that is by filing the S election. So generally speaking, and there can be other reasons, but we're trying to be general here, usually you won't want to be a CCorp for your small business. It's very, very rare that anybody's a CCorp. So we eliminate that one as well as we're trying to pick out what we want to do. So then from there, you're down to an LLC, an SCorp, or an LLP. And how do you break that tie? They both have the limited liability and they both have pass-through tax treatment. You got to figure out, okay, how else are they different that we're going to make a difference? And there's generally a lot of factors that are looked at. The main things that we see looked at as small businesses, and we form entities all the time, are avoidance of ongoing administrative costs, reduction of what's called self-employment taxes, or allowing greater flexibility for equity investment. By equity investment, I mean you want an investor to come in, buy part of your company so you have the funds you need to go do the various things your business plan calls for you to do. There's bank financing and then there's investor financing. Sometimes a big part of what you might do as a small business is start doing well, attract some investor's attention to come in and put some money into your business, and then that allows you to go forward and do well. Allowing flexibility in your entity to allow for that, to create greater flexibility for that type of investment is another thing that people consider. So let's go through them. So avoidance of ongoing administrative costs. When you're a small business, a lot of times, especially at the beginning, you're sort of on a shoestring budget. And so you want to have as few ongoing costs as you can because you're trying to basically keep all your money back in the business, get the thing going, and not have a lot of overhead that's going to cause you a problem. What causes some people to pick an LLC is if you're going to own it on your own, no other partner, you guys aren't partners, it's just you, it can be what's called a disregarded federal tax entity. What that means is there's no we know that as a pass-through tax entity, you're not going to have to pay tax on the higher level. But even with pass-through tax entities, unless it's set up like this, you still have to do informational returns with the state government as well as the federal government. So in other words, even though you're not paying entity level tax, the entity has a tax return and you've got to pay to have that tax return prepared, both on the state and the federal level. With an LLC, you can avoid that because a single member LLC is a disregarded federal tax entity, which means you don't have to file an informational tax return on the federal level. And now that they've gotten rid of the capital stock tax on the state level, you can also avoid it on the state level. So everything flows right down to your tax returns on the individual for the payment of taxes, and you don't have to file returns for the entity itself on either the state level or the federal level. The avoidance of those ongoing administrative costs is something that caused a lot of people to form single-member LLCs. I can't even tell you how many times we form single-member LLCs now, because somebody who would have been a sole proprietor way back when can spend, you know, normally to form a single-member LLC with all your expenses in, and that's assuming you don't have exemptions, it's less than $1,000. It's a lot less than $1,000, and then you never have to pay any more expenses as far as there's no ongoing administrative costs as far as tax returns. So a lot of people pick a single-member LLC. What ends up having people sometimes not be a single-member LLC, though, even if they're an individual owner, is the avoidance of what's called self-employment taxes. So you guys are familiar with like FICA. I'm sure everybody's seen their paycheck get decimated by FICA and everything else. When you are a self-employed person, you have to pay, normally when we all work for whoever we work for, you know, all these years, when you were an employee, you'd have to pay the employee side of FICA and all those things. But when you're the employer, you pay both the employee side and the employer side because you're the entity. It ends up being a pretty big number. And it's capped out at a point, but a lot of times in between, as you're going through it, that ends up being a big expense for some small businesses. So what a lot of people recommend is that people form S corporations. And the reason is this: if you're in an LLC, whether it's a disregarded entity or it's taxed as a partnership, if the two of you are in it together and it's a partnership, partners in a partnership and members in an LLC, with a few exceptions which I'll mention in a minute, can employ themselves. You can't be an employee of your partnership because you're a partner. You can't be an employee of an LLC that's taxed like a partnership for the same reason. So what ends up happening is all the profit of the business is subject to that FICA tax, subject to the cap of when the FICA cap comes in, but all of it's subject to that. Now, if you're an S-Corp, on the other hand, a shareholder of a corporation can be an employee. So what people do, and there's rules about it under the IRS that you have to do it right, you have to pay yourself a reasonable salary, but assuming you pay yourself a reasonable salary, but that's less than all of your profit that you're coming out of the entity, you pay FICA only on your reasonable salary, and the rest comes out as a distribution to you as an owner, and you're not required to pay FICA on that distribution. So that ends up being some FICA tax savings for you, and for a small business, and especially a new one, a lot of times that issue alone is what causes people to be an S-Corp, okay? So, especially when you start out, you might not be making enough money where that would be helpful, so you might say, well, an LLC will make more sense. But then you get to the point where I'm making some more money, and the difference in that tax savings might want me to be an S-Corp. Now, the one thing that some people do is they start off as an LLC, as a disregarded federal tax entity, and then as they start doing better, an LLC can also elect to be taxed as an S-Corp. So once they get to the point where they're making some more money, they go, okay, I know I'll need to do some more informational returns if I make this S election and elect to be taxed like that. But all the taxes I'm going to avoid from a FICA perspective make it worth it. So in any event, sometimes people start as an LLC for that reason, and then as they go along, it has the flexibility of either being taxed if you're by yourself as a disregarded federal tax entity and then electing S-Corp status, or as a partnership to start, and then you can elect to be taxed as an S-Corp. Another thing that causes people to sometimes pick between entities is flexibility in ownership that we had talked about. From that perspective, here's the problem with an S-Corp. It gives you the benefit of that FICA tax avoidance that we talked about. You get pass-through tax treatment, but it has rules in place if you want those. So if you're an S-Corp rather than a C-Corp, you're limited in terms of how many classes of ownership you can have in your entity. So you have to have a single class of ownership, and the rights to that have to be the same. The only thing you can distinguish between in your class of ownership between your shareholders is you could have non-voting shareholders and voting shareholders. The other thing is you can't have non-individual owners. So in other words, you can't have an entity that's going to be a shareholder of an S-Corp. So what ends up happening with a few exceptions, but we're dealing with general rules. So what ends up happening is if you think you might need or want investment from investors, what investors usually, when they come in and they want to invest in a small business, they want two things. They want what's called a preferred class of ownership. Preferred class of ownership generally means I get paid before you get paid as a common shareholder. I'm going to put money in and I'm going to get my money back out and a return before you end up getting your money out, because that's the terms I'm imposing because I have the money. Also, a lot of times it's a liquidation preference. If we liquidate it, I'll get my money out the same way. But most investors are going to want that preferred class of ownership, or else they're not going to invest. The other thing they oftentimes want is they want to invest not in their individual capacity, but through an entity they've formed for the purpose of investing in entities. That neither of those are permitted in an S-Corp. So if you have an S-Corp and you think equity investment's around the corner, they're going to make you change it by the time you get equity investment anyway. So what most people do if they think that's on the horizon is they'll be an LLC or CCorp, but usually an LLC, because that allows for that greater flexibility. Okay? Okay, so when you're making a decision about which form of entity makes the most sense, that's the shorthand for it. But what you really should do is talk to a professional, both a tax professional like an accountant and a legal professional, so that we can walk through your specific, you share with them what you're planning to do, your business plan, the specifics about your business plan, the specifics about you. You know, for instance, if you have major health problems, sometimes those health, the cost of the health and the health insurance can have a different, be taxed differently. You might get a benefit from being something like a C-Corp under certain circumstances. My only point is, the more you can tell your tax advisor and your legal advisor about what your plan is for the entity and what your specific issues are yourself, the better they can pick an entity that's going to be the most preferable form of entity for you. The other thing they can let you know is there's a lot of steps that have to happen in addition to what I'm talking about here when you're forming an entity. Certain entities, like a corporation, you need to advertise their the fact that they were formed in a legal periodical and a periodical of general circulation. So for around here, in the Citizen's Voice or the Times Leader, you have a little ad that says this entity's been formed, and there's a legal periodical, you say the same thing. It's a huge cash cow for all these periodicals, but that's a step that's required to be taken by law when you form a corporation. An LLC, on the other hand, you don't have to advertise that it was formed that way. So you can avoid those costs if you do an LLC versus an S-Corp. So what we generally recommend is that when you're talking to a legal professional, you talk about all the steps that need to be taken so that you don't miss any of them. Because if you miss them and don't act like the entity's supposed to act like, then there's something called piercing the corporate veil, where they say you haven't acted like a corporation or an LLC, you haven't followed the corporate formalities, so you're not going to get the limited liability protection afforded by that entity. So you got to make sure, for lack of a better term, that you dot all your I's and you cross all your T's. And a lawyer can help you know what those are. There's also setting up your organizational documents. So as you're going through it, you'll want to make sure, even if you're by yourself, that you, depending on which form of entity you take, that you set the table the right way. So for instance, if you set up a corporation for yourself, you need to elect yourself as the sole member of the board, or bring on whoever else you might want. You need to elect yourself as, you have to have at least a president, a secretary, and a treasurer. You'll wear all these different hats, it'll all still be you, but the more that you follow those corporate formalities and sign documents as a president and re-elect the officers and directors every year, the more you're going to get the corporate formalities. LLC is the same way. You want to make sure you either select to be a member-managed entity or a manager-managed, and that you follow that protocol, so when you're signing documents, you sign it in that capacity, not with your own name. All those sort of things are things you need to do when you talk to a lawyer. It sounds harder than it is. It's actually, as long as you know the steps, it's pretty easy, but that's what you really should do. So we recommend anybody make sure they get, when they're forming a small business, get a good accountant and get a good legal, somebody who forms these entities on a regular basis like we do, because it's, you go to LegalZoom or something like that, it's just harder to make sure you're doing it the right way. So, with that all said, you've picked the entity you want to form. If you're a veteran or a reservist, and we'll talk what they mean, about what those defined terms mean for the purpose of this legislation that I mentioned. What Pennsylvania has said is, out of gratitude for what veterans and reservists have done for everyone, they're going to waive the fees to file all those formation documents we talked about earlier. It came about in 2016, and the fee includes any fee paid to the Commonwealth of Pennsylvania or any political subdivision for the purpose of starting a new business. And so what that exemption includes, among other fees, is the filing of any of those documents we were talking about earlier. Remember we said for an S corporation or a C corporation, you got to file articles of incorporation. If you're not a veteran or reservist, you got to pay $125. That's waived for you all. Same for a certificate of organization for an LLC. Same for a certificate of limited partnership if you want an LP. Same for that registration we talked about if you wanted to become an LLP, a foreign registration statement, or even the registration of fictitious name. Now, it's not a lot of money, but it's one less bill you have to pay as you're starting a business. And for the purposes of exemption, you have to sort of meet certain criteria. It's got to be a small business, which means it needs to be independently owned, not dominant in its field of operation, and you've got to employ 100 or fewer employees. Now, that's most small businesses, and so that shouldn't be too hard to comply with. It also has to be owned and controlled by one or more veterans or reservists, and we'll talk about what that means in a minute. That means if you have other owners, the veteran or reservist has to own, or the veterans and reservists need to own at least 51% or more of the company, and they need to control it. So if you can have a non-veteran or a non-reservist be an owner of your business as well, but they can't own more than 51%, and they really need to hold the positions of power like president and be on the board and all those sort of things. A veteran for these purposes is an individual who served in the United States Armed Forces, including a reserve component or the National Guard, and was discharged or released from service for conditions other than dishonorable. So, a few good men, Dawson and Downey are not going to be, able to go with this exemption, but anybody else, anybody who's not been dishonorably discharged is eligible for this exemption. A reservist is a member of United States Armed Forces, Reserve Component, or the National Guard. So, as long as you meet that criteria, when you file the formation registration documents, as long as you check the box, there's a box on the form that needs to be filed, and attach proof of your status as a veteran or a reservist, that fee will be waived. You don't have to pay that initial fee at all. The forms that are permitted is a federal DD 214 form, a federal NGB 22 form, valid Federal Veterans Administration card, or a valid Department of Defense issued military identification card. A photocopy of any of those things submitted with your application with the box checked the right way and signed by the veteran or reservist is going to be exempt from that. And I'm actually on the advisory board for the Pennsylvania Corporation Bureau, and I'm privy to their numbers. I know that a lot of veterans in 2008 took advantage of, and reservists took advantage of this exemption. And they were able to save a lot of money holistically, all of them, which is great. The one key is, what the mistake a lot of people make is, number one, they don't attach those things, and then it ends up taking them more time to get your entity approved. The other is, whenever you form any of these documents, there's usually a designation for someone to sign the form. For a corporation, the person's called an incorporator. For example, and for a limited liability company, it's called an organizer. And it's basically usually the owner who's gonna form it. And then that owner later, signs a consent that causes them, as the incorporator to elect themselves as, to designate themselves as the initial board and then issue stock themselves or designate themselves as a sole member. The person signing that form needs to be, the incorporator or the organizer needs to be the veteran or reservist, because what the Corporation Bureau is gonna look at is they wanna match the information on the back of the form about the veteran with the person signing the form. So it's important to do that, because a lot of times, in the past, we would have our corporate paralegal sometimes serve as the incorporator just to not have to bother the client about getting it signed, or you get a service company that would do it on your behalf, and they'd serve as the incorporator and they'd sign it over to you. In this context, to make sure you clearly apply for the exemption, you don't want to do it that way. What we've decided to do as a law firm, in close proximity to me joining as that advisory board and hearing about this great program, I heard about, my grandfather was in World War II. He grew up in Troy, New York. The Troy put out flags for anybody who served in World War II on all the street signs, and he was one of them. And we just saw the picture about a week before I went into this meeting, and it just led me to say, we'd really like to do something to help too. We all sort of have our area expertise, and from our perspective, we talked at the firm and said, listen, any veteran or reservist who wants to take advantage of this exemption, if they want to come in and talk to us, have a free consultation about which form of entity makes the most sense, we'll do that for free, and we'll also fill out those forms for you for free. I can't even tell you how many times people fill them out the wrong way. We do it all the time. It's an easy thing for us to do, and we're happy to do it for any local veteran or reservist. Come in and talk to us about your form of entity. Have your accountant ready, we can talk to him about it as well. And then when you pick which entity you want to do, we'll fill out the form for you the right way. We'll get it filed on your behalf, and you won't have any fee. And then the beauty of that is, with the exception of maybe some advertising costs or whatever else that you might have to pay to those periodicals, if you're an SCorp or if you're an LLC, you could probably form an entity for literally $0, which is great when you're trying to start a small business and do that. So we're more than happy to do it. That explains the rest of it, and just make sure you guys do it right. So if anybody has any questions, that's basically my presentation. I know Brian Stahl, who's going to do the next presentation, is going to give you some additional facts about forming entities and some related subjects. I think we're right about where we talked about. We got 5 minutes if anybody wants to ask any questions, and if not, it was a pleasure talking to you guys about it. I hope I didn't bore you too much.
Yeah, I have more.
Go ahead.
I'm interested in creating a consulting firm. And while I was sitting here listening to you, it dawned on me, although I was interested in the transportation logistics industry,
right.
I'm a retired military policeman, so I have a lot of investigative experience in the Guard and the Reserve, but also on the outside I was in transportation logistics, retention, recruitment, risk management, HR, writing operation sheets, so on and so forth. I'm sitting here listening, I'm thinking I could probably even contract my services to, let's say, law firms to go out and prospect potential investments or businesses or something like that. I mean, because I'm pretty good investigating, I'm pretty good at just observing and watching things. I was wondering if there is such a thing, or if this is all going on in my mind.
Sure. I mean, there's private investigators.
Kind of like a private investigator, but not necessarily. Yeah. I mean, so there's different investigators. It's funny, all you got to find to have a business is a niche of something people are looking for. And if lawyers, so for instance, you all hear about people who are on workers' comp, and then they go on workers' comp, but then they're around the house like doing yard work. There's investigators who go out for insurance companies and just find, and that's turned into a niche business. What we have sometimes, I'm a corporate lawyer, we think that, a shareholder or someone has agreed to a non-compete, or an employee has agreed to a non-compete. And we think they're violating it.
but we can't prove it. So you send out an investigator to follow them around and find out whether they did it. There's all sorts of things like that. So depending on exactly what you were talking about, there might be a niche for it.
I was thinking more in a sense, like, for example, your firm represents John J. Pennypacker, and he's interested in acquiring Dixie Cup Corporation, and then they need someone to go in there and spend a week or two just kind of observing, looking at the books, going through, things like that, just watching, interviewing managers, checking out the departments,
Sure.
that kind of stuff.
I mean, there's people who do that. There's
If
different
there is
reasons.
such a
Yeah, I mean,
need.
I'll give you my card after. Give me a call. I might even be able to put you in touch with
Absolutely.
someone.
As well.
Yeah. Anybody else have anything? Okay, great. I appreciate it, guys. It was good talking to you about this stuff. And if anybody has any questions, my information's on this, or I have cards if anybody needs them. All right.
Thank you.
All right. Thanks. Appreciate it.